Wait and see to make sure that the stream is fired up across the internet. Looks like it's warming up right now as we speak. It usually takes a minute for YouTube to get alive and well, but once it is, we'll get started. And it looks like we're ready to rock and roll, so let's get going. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. We're grateful that you're joining us here today on this lovely Friday afternoon, evening, wherever you are. And we've got a lot to get into, a little heavy lifting today, actually. We're going to be talking about the Equality Act, H.R. 5. This is a new bill that just passed the House of Representatives, something that the Democrats have been trying to get through for a long period of time. Same bill that was introduced last year. Now that they're in control of the House and the Senate and the presidency, we're going to see where this bill is going. It's basically amending the 1964 Civil Rights Act to include sexual orientation and gender identity. So it's sort of expanding the scope of what the civil rights protections include. And it did pass the House of Representatives. We've talked about some other bills here that just have not done that yet. And this is a big move for this new administration. So we want to break that down. We're going to go through the bill. We're going to talk a little bit about the likelihood that it gets passed. We're going to go through some of the specific protections. And then what I'm mostly interested in is sort of what are the ramifications here? Does this create new causes of action? Does this create new crimes? What happens if you violate these new rules? What happens to you? And it's important that I think that we as a society understand that. We're also going to talk more about this other situation out of the Ninth Circuit. So we have talked about the Second Amendment a lot on this channel. Well, not a lot, but enough that it's important to understand what is happening, I think, as it relates to Second Amendment rights. The Ninth Circuit used to be very, very liberal and sort of a court that had no hope of, in my opinion, doing the right thing on the Second Amendment. They have been traditionally liberal, but now they're going a little bit more conservative. There was a ruling where 3 judges basically kept out a ban in California that would have banned and limited the ability to have high-capacity magazines, and that looked like it was settled law. In other words, you could continue to have these high-capacity magazines. And then the court is kind of reversing itself a little bit, or not really, but it's saying we're going to hear this case again. So what happened at the Court of Appeals, well, we're going to get into it, but it's an interesting case, and so we're going to talk about Second Amendment issues as well in the second segment of the show. And then lastly, we got to revisit this Jason Ravnsborg case. Jason Ravnsborg, we've talked about before, and new details are dripping out. If you don't recall, this was the South Dakota Attorney General who was involved in a pretty serious car accident, very serious because it killed somebody. And because he was the Attorney General, we were given this case a little bit extra scrutiny because there were some irregularities there. It seemed to me that he should have had his blood drawn that night, not the next morning, but the police didn't respond. And there's new information that came out today that just confirms a lot of our suspicions that this whole thing was a lot worse than I think that they were letting on to. And so we want to give you some details about exactly what is going on out of South Dakota. So before we get into all that, I want to invite you to join us over at our Locals platform, locals.com/watchingthewatchers. That's where people are asking questions. So as we go through the show, we're going to be taking questions interspersed throughout the content. We're going to break it up into segments. And then at the end of a segment, ask questions. The place to do that is at locals.com/watchingthewatchers. There's a live show thread where you can go on and ask questions, and we'll get to them. So you can also download a copy of the slides over there, as well as a copy of my free book and other goodies, as well as hang out with people and share links and get to know your fellow free thinkers. So let's get into the material. As I mentioned, The first story of the day is the House of Representatives in the United States passed the Equality Act. And so that sounds like a very nice act. We all like equality. We want equal things mostly. And so we're going to break this down, but I want to go through the high level stuff. This came over from NPR, and they're saying it voted on Thursday, so this was yesterday, to pass the Equality Act, a bill that would do what? Ban discrimination against people based on sexual orientation and gender identity. It would also substantially expand the areas to which those discrimination protections apply. Joe Biden on the campaign trail said it would be one of his top legislative priorities during the first 100 days of his presidency. And I think we're at day 37, 36, 38 maybe. The House vote was largely along party lines, passing. All Democrats supported, just 3 Republicans. And now the bill goes to the Senate, where its fate is unclear. And we're going to talk more about that. Democrats introduced the bill last week, and so it's already been passed. Biden said he urged Congress to pass the historic legislation. House of Representatives has done so, and now it's being transmitted over to the Senate, and so we have to see what the Senate wants to do. But presumably, if the Senate passes it and they have the votes to do so, then it's going to land on Joe Biden's desk and it will become law. He's already said it's one of his top priorities in his first 100 days. So we got to understand what this means, how this interacts with some other laws. There's a Religious Freedom Restoration Act that this sort of meddles with a little bit. And so we want to take a look and see how this works. This is over from the congressional website at congress.gov. You can see the sponsor of this bill was Rep. Cicilline from Rhode Island, introduced just about a week ago, so about 10 days ago, not long, moving very quickly along. We can see that it was introduced on the 18th, and then yesterday on the 25th, it was passed into the House. And so it was 224 to 206, so pretty close there. And it's now going to be heading over to the Senate. This is what the summary of the bill says. So this is the congressional summation of what is included in this document. It says the bill prohibits discrimination based on sex, sexual orientation, gender identity in areas including public accommodations and facilities. And so what you'll see here is this list. We're going to go through this and we're going to break it down, but basically they're going through the Civil Rights Act from 1964 and they're just adding in some additional language. So where it used to say, race and sex, now it's going to say sex, including sex orientation and gender identity. So it's just basically expanding the scope. It is changing and adding some other areas a little bit in sort of around the margins. And not really, it's sort of, there is one component that I want to talk about that specifically is basically saying that the Religious Freedom Restoration Act cannot be used as a defense to any claims brought under this section. So we're going to go through that, but I just want to show you that it's just going down a list. It's saying public accommodations, public facilities, education, federal funding, employment, housing, etc., that it's just going in and we're sort of just taking that sentence there, expanding it and shoving the words sexual orientation and gender identity to expand the scope of the Civil Rights Act. And as you can see, there's that list here: housing, credit, jury system, and on and on. Specifically, the bill defines and includes sex, sex orientation, and gender identity among the prohibited categories of discrimination or segregation. So where it currently still talks about, of course, racial discrimination, sex discrimination, meaning by sort of the old definition of gender, and now it's just expanding that pretty greatly. The bill also expands the definition of public accommodations to include places or establishment that provide exhibitions, recreation, exercise, amusement, gatherings, displays, and then 2, goods, services, and programs, and as well as transportation services. So we're doing 2 things. Number 1, we're expanding the definition, so sort of more people are being included, and they're also expanding or more categories are being included as well as people. And we're also expanding the areas in which this applies. So it's also expanding the Civil Rights Act to also talk about places like a gym. And we're going to see here where it's saying that currently there's this debate about transgender people going into locker rooms or bathroom facilities. And so this is expanding to include that. So just keep that in mind. It's not only including the gender identity and the sexual orientation, but also expanding the scope into other areas that previously were not covered by the Civil Rights Act. The bill allows, if there's a violation of this, the Department of Justice to intervene in equal protection actions that are filed in federal court on account of sexual orientation or gender identity. And the bill prohibits an individual from being denied access to a shared facility, including a restroom, a locker room, or a dressing room that is in accordance with the individual's gender identity. And so that's sort of that is the fiery component that a lot of people, at least out there sort of in the culture war, are duking it out over. And so I just want to make a point on that. Right now, as I'm going through this, I'm not particularly interested in an opinion on that. I don't really have an opinion on this one way or the other, if I can be honest. This is one of these things that I think it's important to understand for the trend on where this is going, and I'm more curious just from a lawyerly perspective about how they are structuring it and how the law is interfacing with other areas of the law, in particular the Religious Freedom Restoration Act. And I'm curious about what the framework will look like and how some of the constitutional challenges will move forward as this develops. Now, this may actually have a pretty strong likelihood of passing. We don't know yet. But if it passes the Senate, I'm sure Joe Biden signs it into law. And there's going to be more litigation that results from this, as we're going to see near the end of this segment. So let's dig into it. And I want to be cognizant, right? I want to make sure that we're recognizing that everybody, has a different opinion on this. And the point of this segment is to not create this firestorm of a culture war. I think that largely, from my perspective, that stuff is fine to hash out in non-governmental ways. I think they should be sort of dealt with in the churches and in societal areas, but not so much sort of legislating culture. And so I just want to be cognizant of that we're not trying to light a firestorm. We'll see what happens about that. So this is H.R. 5. This is what it looks like: to prohibit discrimination on the basis of sex, gender identity, and sexual orientation, and for other purposes, in the House of Representatives, February 18th, signed off on by basically everybody. A lot of co-sponsors, all Democrats, mostly, I think everyone. I didn't check every one of them, but a lot of them were. And this is what it looks like. So it says here, to prohibit discrimination, of course, on the basis of sex, gender identity, sexual orientation, and for other purposes. And then it goes through a big, long series of findings. So you're going to see here, we're going to go into the findings and purpose. And number one, the first paragraph, and we're not going to go through all of them. I think there's 26 paragraphs. There's a lot here. So what Congress is doing is they're saying, listen, we have to lay out a foundation for why we think that this bill is necessary, why this should go into law in the first place. And so here is what we are finding. They're voting on sort of the framework, the underlying framework for the justification for the bill. Number one, they say that discrimination can occur on the basis of sex, sexual orientation, gender identity, pregnancy, childbirth, or a related medical condition of an individual, as well as sex-based stereotypes. Each of these factors alone can serve as the basis for discrimination, and each is a form of sex discrimination. So they're going out and defining that. You can have disagreements about it one way or the other, but that's their definition. That's their claim that this is part of the finding. Number two, a single instance of discrimination may have more than one basis. So, for example, discrimination against a married same-sex couple could be based on the sex stereotype that marriage should only be between heterosexual couples, the sexual orientation of the two individuals in the couple, or both. So you could say, well, I'm upset that they are homosexual, or I'm also upset that they are in a marriage that is not heterosexual. So they're just sort of layering on the different versions of discrimination that they've identified. In addition, some persons are subjected to discrimination on a combination of the intersection of multiple protected characteristics, which we know there's a lot of them. Discrimination against a pregnant lesbian could be based on her sex, her sexual orientation, her pregnancy, or on the basis of multiple factors. And paragraph 3, this continues on. Lesbian, gay, bisexual, transgender, and queer people, and then they're going to label this LGBTQ, commonly experience discrimination in securing access to public accommodations. And so this is where we're going into. So that sort of list that we identified that comes out of the 1964 Civil Rights Act, they're going to go through it item by item. I'm not going to spend all the time on this channel doing it, but that's what they're doing. So they're saying LGBTQ, no access to public accommodations or discrimination in the process of getting access to centers, stores, establishments, healthcare facilities, youth service providers. Forms of discrimination include the exclusion, denial of entry, unequal, unfair treatment, harassment, violence. This discrimination prevents the full participation of LGBTQ people in society and disrupts the free flow of commerce, which is, I thought was interesting that they're sort of bringing commerce into this. We also have women, paragraph 4. Women have also faced discrimination in the same establishments. So they go from LGBTQ to women now, same thing, stores, restaurants, places, establishments, and on and on and on. And they just kind of go through the list. So we're going to skip most of those paragraphs that are laying out the foundation, and we're just going to jump down to section 23. So section 23 here says, as with all prohibitions on invidious discrimination, this act furthers the government's compelling interest, and so this is another finding, in the least restrictive way possible. Only by forbidding discrimination is it possible to avert or redress the harm. So they need to do that. Then we jump down, so you can see 23, 24 different paragraphs explaining their findings. We're going to jump down to the purpose section. And what is the purpose of the Equality Act? They say, it is the purpose of this act to expand as well as clarify, confirm, and create greater consistency in the protections and remedies against discrimination on the basis of all covered characteristics, and to provide guidance and notice to individuals, organizations, corporations, and agencies regarding their obligations under the law. And this is something that, oh my goodness, I think I'm missing a lot of slides here. What happened to my next slide? All right, so we're gonna just continue on. I don't know where some of my slides are. Not a big deal, but we're gonna just, the point of all of this is there was a Religious Freedom Restoration Act. So the sort of the ramifications from this new bill that is now in the Senate, contemplating being signed there and passed over to the White House so that Joe Biden can sign it and it officially becomes law, is this relationship between civil rights. And there's a different section of this law that is not in my slides for some reason. It's not syncing up, but it says there, the Religious Freedom Restoration Act, which is a separate bill, which was passed in 1993. There's been a series of Supreme Court case laws basically upholding it, and it's sort of raising the standard on some of the religious claims that people make. So in other words, it's saying that you have the freedom, more freedoms that are protected under this new 1993 act to practice your religion. And so if you've been sort of paying attention to popular culture and some of the lawsuits that have been taking place, you may have heard about these bakers who don't want to bake a cake for a gay wedding. And these things turn into little cultural bombs that explode every now and then. And in my mind, it seems like it's a lot of sort of antagonism that is needlessly done. People demand that a cake be made, and the bakers demand that they don't have to make a cake, and it's all just about a cake and a wedding that probably those people would never do business together anyways, unless they were trying to make a political point, and they both sort of dig themselves into the ground, and then they become this big political spectacle. So the point here is that what the difference is, now we've got a civil rights bill that is subject to being modified, and we also have a religious freedom bill. And what this new civil rights component under the Equality Act, what it's doing is it's saying, if you are discriminatory and you violate this act, you cannot use the Religious Freedom Restoration Act as a defense. So if this goes into law and now you're a baker and you don't want to bake that cake, well, you certainly have to. You cannot use that as a defense. And if you continue to do that, and I know there's been more case law surrounding this issue, but I'm just going back hypothetically and sort of fleshing out how this works. If you're a baker and you don't bake that cake anymore, you are now being discriminatory. You're now in violation of the 1964 Civil Rights Act as modified by the 2021 Equality Act, and then that's going to subject you to liability. Somebody can file an equal opportunity claim against you, a violation for that, and as this act says, the Department of Justice will now get involved, and you can be liable for damages for that. So you just got to be extra cognizant of that this is potentially a new claim, especially if you're a business owner, you're somebody who deals with employees, or you have people coming in and out of your store. These are prospective new claims that you may not have been anticipating before that can come down the pike. Now, this has not been passed yet, and the question is whether or not it will. I wanted to pause briefly, though, and just change gears and show you that this seems like there was another change that was also coming out of the Biden administration where they're dropping a lawsuit that is kind of closely connected to this. And so I wanted to show you sort of both ends. So legislatively, Congress is moving forward. They're passing the Equality Act, and they are trying to see what the Senate will do. But simultaneously, sort of coming at the same issue from a different angle, is the executive branch. And so Joe Biden and the Department of Justice, there was a lawsuit that was pending previously, specifically by 3 female high school athletes who filed suit in Connecticut, and they were claiming under a different section. So see how we're having these interfaces under Title IX. So if you understand Title IX, that is basically a provision that says we need equal opportunity in schools, especially as it relates to sports and especially female sports. And so they were bringing a claim under the Trump administration, under Attorney General Bill Barr, to file this suit and say, hey, we are competing against biological males. We are biological females. These biological males have transitioned, so now they are female. Their gender identity has become female, but they're biological males, according to their lawsuit. This is not me saying that, but they're saying they're biological males, and they are beating them in sports. And so they're saying that's a violation of Title IX claims. So now you have multiple competing governmental laws. You've got this new Civil Rights Act, which expands and includes those things. You've got the Title IX Act, which there's a new lawsuit, or there was a lawsuit that the Biden DOJ is dropping. And you also have the Religious Restoration and Freedom Act. So you've got this interplay between all of these different laws that are going to be just beating each other over the head. Which one supersedes the other? And how do you decide that? So it's going to be an interesting sort of a legal mess. It's going to be a mess, I think. Here it is. This comes over from Breitbart.com. It says Joe Biden's Department of Justice withdrew its support for a lawsuit brought by 3 female high school athletes in Connecticut, claiming that females being forced to compete against biological men violates Title IX. So sort of like the Religious Restoration Act, Title IX now is also being brought into play. And previously, Trump's DOJ, led by Bill Barr, backed the lawsuit, agreeing that women were being denied Title IX protection. Under the CIAC interpretation of Title IX, Barr said in March 2020, schools may not account for the real physical differences between men and women. Instead, schools must have certain biological males, namely those who publicly identify as female, compete against biological females. In doing so, CIAC deprives those women of single-sex athletic competitions that are more of a marquee one of the more marquee accomplishments of Title IX. One of those athletes, Alana Smith, and her lawyer, Christina Holcomb, who was with the Alliance Defending Freedom, they were a guest on Fox News. They say fairness needs to be restored in our sport and all other women's sports. These biological males are just taking it away from us, Smith said when asked why she and her fellow athletes filed a lawsuit. Lawsuit was filed in federal court, 3 high school girls and their mothers, against the Connecticut Interscholastic Athletic Conference, which has permitted boys to compete in events and win awards that would otherwise have gone to girls. Selena Soule, Alana Smith, and Chelsea Mitchell, represented by Alliance Defending Freedom, were denied opportunities to compete at higher levels as boys took home the prizes. This is according to their document. CIAC's policy allows 2 males to compete in girls' athletic competitions beginning in the 2017 track season. Those boys have taken 15 women's state championship titles held in 2016 by 9 different Connecticut girls, and have taken more than 85 opportunities to participate in higher level competitions from female track athletes in the 2017, 18, 19 seasons alone. Smith said, I got involved after I ran against biological males at the New England meet because in the 200 meter, I took 3rd place when I should have gotten runner-up. And it's not really about placement, but it's all about knowing that I worked so many hours a week to be able to get runner-up in New England's championships as a freshman. And I'm really disappointed in the news because me and other girls, Selena and Chelsea, have worked really hard to get our stories out there, to get people to realize that fairness needs to be restored in our sport and all other women's sports, Smith added. And so, you can see that if the Equality Act passes, now we've got these claims. They're sort of at odds with one another. The high school girls here are saying, no, we think that there are some pretty serious differences, and basically they're asking for a segregation there based on biological sex, based on biology, whereas the Equality Act doesn't make distinctions for that. It's based on a specified gender identity as is written into the new bill. So they're going to be at odds with one another. The lawsuit, according to Alana, or Holcomb, her attorney, says the lawsuit absolutely moves forward, but as you mentioned, this was clearly a politically motivated decision to side with radical activists over female athletes like Alana. So the DOJ under Trump was supporting this lawsuit. They were saying, yep, we're going to intervene because it's a violation of Title IX, what Connecticut was doing. Well, now there's been a changing of the guard. So now Joe Biden and his DOJ is saying, nope, not so much anymore. We're not going to support that, which mirrors what's going on with the Equality Act. So equality, I think, will take higher precedence. Those civil right claims will beat out the Title IX claims, and they'll beat out the Religious Freedom Restoration Act claims. That's just how the different competing government established rights are going to be jockeyed on the hierarchy. You can have a lot of disagreement with that. I'm sure a lot of people do. But what's even more concerning in this effort to gut legal protection for women is not just isolated to what we see in Connecticut, Holcomb said. Even now, the Biden administration is pushing the so-called Equality Act, which ignores the real physical differences between men and women and threatens women's privacies, women's homeless shelters, and yes, even women's sports on a national level for female athletes like Alana. The House, in fact, passed the Equality Act 224 to 206 on Thursday. It expands the definition of biological sex to include gender identity, opening the door for more legal challenges. Title IX was designed to ensure that girls like Alana have a fair and level playing field, have a chance to showcase their talents, to be champions, and frankly, to earn those college scholarships, Holcomb said. So we want to move forward and we want to see women's sports protected across the country. We've got a lot of different rights sort of competing against one another, and we'll see where it goes. We do know that Representative Chip Roy, who was over at a House Freedom Caucus press conference on Thursday, he's not happy with the Equality Act. He decried it. He said it passed, but he said he's vowing that legislation will continue to face opposition, including in the nation's courts. I'm proud to stand with this group. We'll oppose this legislation, but we're going to keep fighting into the courts and beyond, but most importantly, through free will as American citizens and our right to live free, and to alter this government as necessary if they continue to trample our rights. Texas Republican blasted House Democrats during his remarks, saying that, quote, this body being led by Democrats is trampling on the rights of the American people in the name of equality, in the false name of equality. And so here is Representative Chip Roy. This was, looks like this morning, yesterday.
I'm really proud today to be associated with this group. It's the House Freedom Caucus. We're standing in front of an institution, the United States Congress, which is fundamentally broken to its core. It is no longer representing the values of the American people. It is no longer doing what it is called to do to secure the blessings of liberty as is outlined in the Constitution of the United States, but rather, this body, being led by Democrats, is trampling on the rights of the American people in the name of equality, in the false name of equality. The Declaration is clear. All men are created equal, endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. But government is instituted among men to what? Secure those rights. Look around. This is about power, ladies and gentlemen. And you in the media should be as concerned about this as anyone else. It is your job to hold government accountable and get information to the public to know what's really going on, and look around. Look at the fences. Look at the razor wire. This isn't a free society. This is a government using its power to tell us to bow down to the will of a cultural elite in this town who want to tell us what we're supposed to believe. We're not going to do that.
I think that's going to be the typical response. You know, this is stuff that I think is going to get, more, I would say more heated before it gets any better. There's going to be a lot of lawsuits that take place, and you're going to see people who just feel like their religious freedoms are being stripped away from them. And that is not a good feeling, right? For people, they want to be able to practice their faith appropriately. And if they think that, they're going to have to start sending their 12-year-old daughter into a schoolroom with a 12-year-old biological male who is transitioning, I think the more and more people are sort of faced with those decisions, we may see some public perception, some public opinions change. Right now, a lot of this stuff is hypothetical, but we haven't seen it trickle down. Now, I'll be honest, I don't have much skin in the game on this particular issue. I don't have kids. I am religious, but not to the point where I have any particular issues with any of this stuff. To me, this is sort of outside of my wheelhouse in terms of having skin invested in how this comes out one way or the other. I am not somebody who has a fluid gender identity or anything like that. And so I don't know how sizable this population is in this country and whether this is an issue that it really is affecting so much of the country that it needs to be as big of an issue as it is. And so, I understand this concept that if there's injustice anywhere, there's injustice everywhere, and some of these big, concepts that we have to act to secure some of the unrepresented people in this country. And I know that many people in the LGBTQ movement, believe that, and I can't speak to that, right? I'm not in that movement, and I don't identify with it, and I'm not familiar with the intricacies of it. So, this is stuff that I think is mostly cultural war, and it can get very heated. And so, as I said, from my perspective, I'm just more interested in sort of the interplay between these different rights. And, at some point, maybe I will have a daughter, and maybe I'll have, some more skin in the game. And at that point in time, maybe my opinions will modify. But as it stands, let's just jump into the questions. Hack Consulting says, you know what? Make the Civil Rights Act as inclusive as possible. The more they do it, the more worthless the thing becomes. Barry Goldwater had a point in betting and being against it. Let's help the Dems destroy it. And yeah, I can understand that perspective there, Hack. It's if everything is something, then it's like if everything is racist, then is anything really racist? Right? If everything is racist, then then is anything racist? If everything's a civil right, well, then what about the things that really are civil rights? What about the things that should be protected? Maybe we're just including a bunch of stuff that doesn't need to be included in that. Now, I don't know. As I said, this is I think a broad expansion that includes a lot of stuff, opens up a lot of liability for people. Now, if you use the wrong pronoun, are you going to be sued for discrimination? I don't know, but that would be my big concern. Whether what is the scope of the claims that this opens up? Paula MK says, where is the inclusion for political affiliation? Yeah, it's not in there, right? Not in there at all. And I wouldn't expect it to be. We have Sharon says, this bill will destroy women's sports. We discussed this before your show when you told how it was to be in a wrestling match with a woman. Women are not men. Yeah, I remember talking about that. They are genetically different, and to ignore the basics of genetics is anti-scientific. The stipulations regarding sexual orientation could infringe upon the rights of religious organizations to determine those whom they will give sacraments. The bill completely ignores biology as well as religious liberty. Very good points there, Sharon. And I think that, I think those are very good points. And I think that they're going to have to sort of answer those things. And so largely what I was thinking is that practically, let's see how this goes. What happens if we try it? Okay, so what happens if we say, all right, we're going to let people who are born biologically male compete in women's sports? Is that something that really is happening a lot? Like I've seen clips here and there of, certain individuals just smoking everybody else on the field by laps because of their biological differences. And, is that commonplace? Is it? Or is it going to be a lot more commonplace? Because if it is, a lot of people sort of, they like the idea of a lot of these changes in society, but when it hits them at home, when their daughter wakes up and she gets blown out by somebody else who's twice as fast as her, how is that going to impact how they believe, about some of this stuff? Are our opinions going to be modified as this issue develops? And so what you're saying here, I do think makes sense. There are pretty strong differences between men and women, as I discussed in my wrestling story. I don't give a damn about any of this stuff. These people need to stop coming into my business and talking about their weird kinks, licentiousness, and other things that do not contribute to the purpose of creating products and providing services. Y'all can have all the equality you want outside of my business. Get out, hire some illegals to do a better job than these Zoomers, Tide Pod, Jazz. I'm not your welfare check. Oh, Hack, man, you are on one. That's beautiful. That's a rant. Do you feel good? Do you feel better about that? I feel better for you, man. You just smashing that keyboard. I love it. Good stuff. We have Nadar Blasier says, according to Lauren Bobert, parents that choose not to give their kids puberty blocking drugs could have their kids removed from them because it's considered child abuse under this bill. Parents that choose to give their kids puberty blocking drugs could have their kids removed from them because it's considered child abuse under this bill. So did you copy and paste that twice? Or did I miss something there? Yeah, so I didn't see anything. I read through it, and I don't know why my slides aren't popping up. I actually had a lot of the clips from the bill, but it's all right. A lot of the same penalties were very similar to what you already see under the 1964 Civil Rights Act. You have to go and file an equal opportunity violation or equal protection claim is what I'm thinking of. So if you were to do that, you'd have a lot of the same claims. Here, though, I didn't see anything specific about, parental hormonal stuff, but you could see where, if one parent is under the belief that their child needs to be put on hormone blockers and start transitioning, and another parent disagrees. Well, now you've got this as a civil rights issue. That gender identity is a civil rights issue, and that is an important thing. And so that is going to go into the equation when parents are divorced and they're just, having decisions about whether to transition their 4-year-old, 6-year-old, 8-year-old, 14-year-old. It becomes a civil rights issue under the Equality Act. And how does that interplay with parental rights and custodial rights and all of that stuff? Sharon Quidney says, this forcing people to do things which are morally objectionable to them is essentially enslavement. I thought slavery was illegal. It is illegal, but it's I think it's something different, obviously, than slavery, but it is troubling. And I think that's troubling across the board when the government is sort of interfering with a lot of, how you conduct your stuff. Now, you could have, so conversely to that, you could say, well, you talk a lot about a digital bill of rights and how about digital freedoms and digital, right of expression and that type of stuff. And so I think that's a fair criticism. You could just say, well, it's just a different standard. We're elevating the standard. We think that these are civil rights that should be embodied in our law. Just like, nowadays we all believe that racial discrimination is wrong. It's pretty uniform, right? But back in the 60s, maybe that wasn't so uniform. And so I think what a lot of people on the left who are in support of this, they're saying it's basically the same thing, right? 40 years from now, 100 years from now, we'll look back and we'll say, oh yeah, of course, gender is decided. It's not defined at birth. This is something that is fluid, and we as a society are more malleable with it. And maybe they'll look back on this era and they'll say anybody who was opposed to that was like a racist. Now, I'm not so sure about that. I think we're talking about a little bit different things here, but I think that is if you had to steel man the opposing argument, I think that's what they're saying. We have another one. Shades says, living in beach areas in California, many businesses don't allow you in the store and restaurants unless you have shoes, a shirt on. Curious, is this different than a cake? Well, I think, yes, it is. So I think that the cake is based around sort of what they were saying is that getting married is now a constitutional right. It's been recognized by the Supreme Court if you are a homosexual couple, same-sex couple. We saw that in the Obergefell case. And so what they're saying is we now have a constitutional right. Somebody's refusing to make a cake for us. That's infringing on our constitutional rights. Therefore, that's a violation of our civil rights, filing claims against the baker, make the cake. And so it's sort of an extension of, I think it's antagonistic litigation. It's out there to prove a point, right? And make a political statement, and they succeed in that. But that's different because we're talking about a fundamental right, which is marriage. We're not talking about a fundamental right. The Supreme Court has not said that you have to have shoes on or you can't discriminate against people who do not have shoes on. So it's a more substantive right, which is why it gets that higher standard. Jeremy Matrita says, ever notice that the Democrats like to write bills that do the opposite of what they are doing? Proposing a Civil Rights Equality Act is more like a Civil Rights Infringement Act. Well, so it does. It infringes on other rights. So it infringes on the right of the high school girls to compete in a biologically homogenous competition. It infringes on the religious people for their ability to decide that I don't want to go and bake a cake for something that I disagree with. And so, yeah, it is infringing on rights. It's this discussion about which rights supersede the other. What does the hierarchy of rights look like? Chris Wiseman says, I can't see how they're stripping RFRA protections. I can't see how there is stripping RFRA protections won't create serious issues when RFRA requires a showing of sincerely held beliefs, whereas transgender requires no such standards. Great point. As written, it is purely subjective to what the individual feels at any given time. I can be trans from 3:30 to 5 so I can play in a girls' varsity basketball team, and male the rest of the time. Yeah, that's true. I mean, there really was no, in my reading of it, not a super long bill, but if you read through it, really no, qualifications for that. You just kind of just get to decide. And if anybody has an objection to that, well, what can you do? It's in the law and it's signed into law. But I think, Chris, you're absolutely right. There are different standards here. And remember, the Religious Freedom Restoration Act, I mean, that is that was subject to a lot of litigation. I think there was a Supreme Court about that we read in law school. But it was something that, in my opinion, is sort of based more off of the free exercise clause that we see in the First Amendment. This other civil rights stuff, the constitutional underpinnings are very strong. We have equal protection under the 14th Amendment. The 1964 Civil Rights Act has a lot of constitutional backing, case law just all over the country. But it's ballooning. It's getting bigger and bigger. And you can have disagreements about whether that's justified or not, but it is. And the further and further in scope it gets, you have to ask yourself, can we connect that back to the constitutional underpinning that justifies the decision, the government action down the line? And that's where I think a lot of the litigation is going to come into play. We've got Paula MK says, since this bill basically cancels out other laws like religious freedom ones, is this something that is going to end up endlessly litigated in the Supreme Court? Yes, I think so, Paula MK. And I'm not real sure how that's going to end up. We'll see. We'll see if it's a 9-person court or 15-person court. But I do think that it will go all the way up because you've got two competing interests now that the government created. You have the Religious Freedom Restoration Act that was passed by Congress. You have the Title IX, which was passed by Congress. Now you have this new amendment, which is also passed by Congress, and they are directly at odds. So how is that going to get sorted out? The courts will do it. We have Nadar Blasier says, there's a lot more issues to it than religious. Look at the suicide rate of trans people and how many of them regret getting sex changes. They never talk about that. Yeah, there's going to be some social repercussions for it. And there's going to be, what if you're a counselor and now you advise a parent not to transition a child? You say, I don't, I think this is a phase or something like that. I don't think that this is the right move for you. You're a doctor. You're somebody with a medical background. You say, I'm not so sure about that. Are you opening yourself to civil liability under the equal protection standard that was set in this bill? Can the Department of Justice sue you for that because you're infringing upon civil rights? Can another co-parent, file a claim against you for making an opinion or speaking out in that manner? Or what if you're advocating about this stuff now? What if you're out there being a proponent of saying, hey, we should have biological standards in female sports? Well, if this goes into play, now you're somebody who is speaking out against civil rights. And can somebody bring a claim against you for that? Another concern. As I understand it, it also strips the RFRA protections for physicians who could otherwise refuse to perform abortions based on deeply held beliefs, as well as churches that must now perform same-sex weddings and will likely lose their 501 status for violating the law. I think those are both very good points. Yeah, I did see a section in there about not being able to deny people access to sex treatments. So anything sort of involving any of that is covered in the purview there. And we'll see what other claims it makes. I mean, it's sort of a broad revision. It's just going down and amending a bunch of stuff. All right, so that was the last question on that segment. Apologies for not having my slides in order. Not sure what happened there, but I'll go take a look after the show. All right, so let's change gears. The Ninth Circuit Court of Appeals used to be very liberal. Then we got a little bit of a change over the last 4 years with the Trump administration, and now they have been trending a little bit more conservative. Previously, we had a ruling out of the Ninth Circuit that was removing a ban that California had put in place to prohibit people from having high-capacity magazines. So we're talking about firearms. YouTube doesn't like when we talk about that, so we're going to just talk about these things as Second Amendment issues. And so there were new laws out of California that were infringing upon people's ability to have high-capacity magazines for their Second Amendment devices. And there very recently, there was a change in that. We thought that largely that this ruling would stand, that the Ninth Circuit would stand by their ruling, but they are now allowing the government who wants to impose the ban, who wants to bring it back out, they're allowing them to be reheard on the case. And you're thinking, well, wait a minute, I thought it was a final ruling. Kind of, but not quite. So let's dig into this story because we're going to be revisiting this very soon. The Ninth Circuit Court of Appeals eyes the California ban on the high-capacity ammo magazine. So on Thursday, it will reconsider a 3-judges court split ruling last year that threw out California's ban on high-capacity ammunition, a decision with potential impacts in other states. There's an 11-member panel on the Ninth Circuit Court of Appeals. They are going to rehear the case after 2 members of the 3-judge appellate panel ruled in August that California's ban on these magazines that hold more than 10 bullets violates the U.S. Constitution protections of the right to bear arms. So what this is saying is, back in August, there was some litigation going on. We're going to go through some of the case history here briefly, but what they're saying is there was a ban that was passed into law. The lower court said, no, you cannot do that. That's infringement on the Second Amendment. It went up to the Court of Appeals. The government appealed and went up to the Ninth Circuit Court of Appeals. The Ninth Circuit then, the whole court didn't hear everything. So they have these hearings where basically 3 members, there's a panel of judges on the appellate panel who will hear a case and grant a decision. Then if they sort of request that the entire court hear the case, then the court can re-vote on it and they can bring back in all 11 judges. So the reason they split it up into sort of smaller contingents is so they can process more cases. Okay, we got a lot of cases coming through here. 3 of you go handle that, 3 of you go handle that, 3 of you go handle that, and so on. But if that ruling is not favorable, or if there's disagreement amongst that, so if the 3 judges go and they issue a ruling, they say, we heard the case, we heard the arguments, here's our opinion, this is what the order of the court is, then they can go back to the full panel, and if the full panel votes, if enough of the panel votes to hear the case, then the case comes back up and all 11 people hear it. So even though the 3 people ruled that this ban was unconstitutional, now that it's coming back up, the full panel could reverse that. So this sort of position that many people in the Ninth Circuit, which covers a lot of states, Arizona, California, I think most of the West Coast is in there. If it changes, then now we're going to have a circuit that says you can ban high-capacity magazines. And so the original underlying law was about 10 bullets, which was the limitation that we saw out of California. This article goes on. The 3rd member had said that ruling conflicts with decisions in 6 other appellate courts across the nation and with the 2015 ruling. The 3rd member had said that the ruling conflicts with decisions in 6 other appellate courts across the nation. So we may have a split series of circuits. Advocates on both sides said they are eager for a rematch, a reflection of the changing nature of the federal courts. The once notoriously liberal Ninth Circuit has shifted to the right with recent appointments by President Donald Trump, and Second Amendment advocates are anxious to get such laws before the more conservative U.S. Supreme Court. However, a majority of the nation's high court in June declined to consider several challenges to federal, state, and gun control laws, including Massachusetts' ban on large-capacity ammunition magazines. We're excited to have another opportunity to defend what Californians already know: law-abiding citizens' ability to purchase, possess, and use standard capacity magazines. To purchase, possess, and use, they're saying it's a fundamental right and shall not be infringed. Now we have the state attorney general, Xavier Becerra, who is awaiting confirmation of Biden's new cabinet. He called the rehearing decision critical and said the next step in the defense of our state's common sense gun laws. Common sense gun laws. Don't you like that? Everything's common sense when it comes to the guns. All right, so here is the order. And I want to show you just sort of practically how this works. We can see it's Virginia Duncan versus Xavier Becerra in his official capacity as the AG, Ninth Circuit Court of Appeals. This one was filed yesterday, February 25th. Signed off on by the judge, Chief Judge Thomas. Upon the majority of non-recused active judges, it is ordered the case be reheard en banc pursuant to the Federal Rule of Appellate Procedure 35. The 3-judge panel opinion is vacated. Judge Owens and Bress did not participate or vote in this case. So there was a ruling, which was a good ruling if you're a Second Amendment advocate, and now they're saying that's vacated. It's gone now. We're going to rehear it, and they're going to rehear it soon. So let's go through what the original opinion was, because we know at least 2 out of the 3 judges were in favor of this position. There is one judge who dissented, and there's 2 other judges who said this is the right way to address this issue. So what are we talking about? Here is the underlying case. As you can see, this one was filed August 14th, 2020, up here, same circuit, 9th Court. This is the opinion, same individuals, same parties. We got Virginia Duncan versus Xavier Becerra. An appeal from the United States District Court. We got Roger T. Benitez presiding. And he is the guy who's in the thumbnail. Argued and submitted April 2nd, filed August 14th. All right, here it is. So let's go into some background a little bit, and then I'm going to show you the structure of this. So it's a pretty long opinion. I think it was 81 pages. I did a synopsis of it. So I'm going to go through and I'm going to show you what they're arguing. So the way that this opinion is read, we've got a background, and then we're going to go through the framework of the analysis. So what are they talking about? Right now they're talking about these LCMs. California Penal Code, Section 32310, prohibits people from owning LCMs. Those are large capacity magazines. See this? In 2016, California passed a law to enact a wholesale ban on the possession of LCMs by almost everyone, everywhere in the state of California. Any person in this state who possesses any large capacity magazine, regardless of the date the magazine was acquired. And so what they did is, if you had a magazine, and we have seen this bill or seen this language in a federal bill. We talked about HR something or other that's in the House, and this was part of that language where they're saying, look, if you have one of these, it is now illegal. So you're going, well, wait a minute, this used to be legal. I just bought this thing. It was illegal 5 minutes ago. You're now telling me I'm a felon for being in possession of this thing? How does that work? Here it goes on. 32310 has not always been so broad. It was originally enacted in 2000. It prohibited the manufacture, incorporation, or sale of LCMs. So what they wanted to do is limit the creation of new LCMs, but it got modified. So now if you even have one, that is also illegal. It's illegal to go buy one. It's illegal to sell one. It's illegal to import them. That was the first version, but then it got modified. Now it says, well, if you already did that, it's illegal now. 10 years later, California declared unlawfully possessed LCMs to be a nuisance subject to confiscation and destruction. They further extended that law to prohibit the purchase and receipt of these LCMs. It may seem that after the 2013 amendments, California had completed the circle in regulating the LCMs. By then, the state had long since foreclosed the transfer, the sale. 2013, it prohibited the purchase and receipt, but the law still allowed Californians who already bought them before the enactment to keep them. But then, in 2016, they passed Senate Bill 1446 that prohibited the possession outright. A few months later, Prop 63 was passed, which strengthened its prohibitions by providing that possession may constitute a misdemeanor offense punishable by up to a year's worth of jail time. So with the stroke of a pen, Prop 63, you're in possession. Now it's a misdemeanor. Now you could go to jail for a year. The law as amended also requires citizens who own LCMs to remove the magazines from the state, sell them to a firearms dealer, or surrender them to law enforcement for its destruction. So you've got your own private property. Prop 63 passes, and they say, you know that stuff you have? You got to go take it and get rid of it. Sell it to, go give it to a state, take it out of the state, give it to a firearms dealer, surrender it to law enforcement for destruction. Just confiscating. So people say that people are sort of hyperventilating and freaking out about gun confiscation. They did it. They passed the Proposition 63. Now, it wasn't the firearm itself, but what good is a firearm without a magazine? What good is the gun without the ammunition? I shouldn't have said that word. What good is your Second Amendment boom boom stick without the ammunition? It's not that good anymore. We have, under the Penal Code, LCM owners may permanently modify non-conforming magazines to accept 10 rounds or fewer, thus removing those magazines from the definition of what constitutes an LCM. So you can just wreck it. Okay, if it's a 30-round magazine, you just got to wreck it so it can only hold 10. All right, that's another option for you. This is the summary of the case. The panel affirmed the district court's summary judgment in favor of the plaintiffs. So what this means is, as this lawsuit was bubbling up, the district court, which is the lower level federal court, before you get up to the Court of Appeals, which would be the Ninth Circuit, they filed a motion for what's called summary judgment. Basically, hey, we presented our case, find in favor of us, we don't need to go forward with a full trial. We're moving for summary judgment. What do you think? Plaintiffs were challenging the government code. They won. Then it went up to the Supreme Court, and the Ninth Circuit Court said basically, we affirm that lower ruling. The ban is unconstitutional. The district court said, not allowed to have that ban. Ninth Circuit affirmed that, and this is their reasoning. This is how they came to that conclusion. The Ninth Circuit employs a two-prong inquiry to determine whether the firearms and the regulations, whether they violate the Second Amendment. They're asking two questions. Number one, whether the law, so whether this prohibition burdens conduct that is protected by the Second Amendment. So in this case, would possessing a magazine that is considered and defined as an LCM, would that ban burden activity that is protected by the Second Amendment? I think the answer is unequivocally yes. If so, what level of scrutiny to apply to the regulation? So we've talked about this before on this show. We talked about the different levels of constitutional scrutiny. We have the rational basis, which is the lowest. Sort of if the government can find any rational basis, any conceivable reason for doing something, it's not infringing on a protected fundamental right. So they're given a lot of leeway to do what they want to do. If the government's going to impose something for you to do or impose a regulation, if it's if that action, if that law is infringing on something that is not a protected right, then they can kind of do whatever they want. Rational basis scrutiny. We have intermediate scrutiny, which we kind of see pop up in case law from time to time. Then we have strict scrutiny. And that means that it's a lot higher because the government is impinging upon a fundamental protected right. And so in order for them to be successful, in order for that new regulation, or in this case, a new governmental ban to be upheld, it's got to pass strict scrutiny, which means it's infringing on your Second Amendment right. So therefore, it has to be absolutely necessary. And the government, in other words, has no other way to enforce or to achieve their goals. It's necessary in order for them to pass this regulation. And this regulation is the least restrictive way for them to achieve that. It's necessary, and the government has tried everything else. This is the only thing we can do. So that's kind of the second question. Does it pass? First of all, what level? Is it rational basis, intermediate scrutiny, or strict scrutiny? And if it is strict scrutiny because it's burdening a Second Amendment right, how do we analyze it under that standard? That was like a lot of constitutional stuff right there. If that went over your head, don't even think twice about it because it almost did mine also. The panel held that under the first prong of the test, California Penal Code did burden protected conduct. First, the panel held that firearm magazines are protected under the Second Amendment. So the Second Amendment includes the magazines. The panel held that LCMs are commonly owned. They're typically used for law enforcement purposes and for lawful purposes. They are not unusual arms, quote, unusual arms, that would fall outside of the scope of the Second Amendment. Third, the panel held that LCM prohibitions are not long-standing regulations and do not enjoy a presumption of lawfulness. Fourth, the panel held that there was no persuasive historical evidence in the record showing that the LCM possession fell outside the ambit of the Second Amendment protection. Proceeding to prong two, the panel held that first, strict scrutiny was the appropriate standard to apply, the higher level there. So if it's strict scrutiny, it means they're going to be looking at this ban intensely. They got to make sure if this ban is to be upheld, that it is absolutely the least restrictive thing that they can be doing in order to achieve their goals, and it's necessary to achieve those goals. The panel held that the Penal Code law struck at the core right of law-abiding citizens to self-defend by banning LCM possession within the home. It goes directly to the core right. Second, the panel held that a near categorical ban, so all LCMs, that it substantially burdened the core Second Amendment right. Pretty obvious, right? There's sort of no exception for that. Third, the panel held that the decisions in other circuits were distinguishable. So we have other circuits who are upholding similar bans, and they're saying, well, yeah, but those cases were different. This is a little bit of a different situation. It's a different law. It's a different rule. It's a different jurisdiction. They have different regulations. They can distinguish them from this instant. Fourth, the panel held that this circuit's decisions in FIOC did not obligate the panel to apply intermediate scrutiny. So they're not even going to talk about that. They just went with strict scrutiny. The panel held then, so now that we know this analysis here is this a fundamental right? And the answer is yes. It's the Second Amendment. And there's no exceptions that would move it outside of the purview of the Second Amendment protections. So we now that we know it's a fundamental right, it's something that is very important. We're going to apply strict scrutiny. So they go through the strict scrutiny analysis here, and then this is where they're discussing what standard to use. They decide on strict scrutiny. Then we have down here some strict scrutiny analysis. The panel held the California Penal Code did not survive the strict scrutiny review. Why? First, the panel held that the state interests advanced here were compelling. So the government is saying, we want to prevent and mitigate gun violence, right? We all want that. We understand that. The government does have a compelling reason. Nobody wants unnecessary gun violence to happen, including the government. It is compelling. But the panel held that this law was not narrowly tailored to achieve that interest, that compelling state interest that it purported to serve, because the state's chosen method, which was a statewide blanket ban on the possession everywhere and for nearly everyone, was not the least restrictive means of achieving the compelling interest. So we know it's a protected right. We know that strict scrutiny applies. We know that even the government has a compelling interest to want to enforce that ban. That we don't have to agree with that interest. We don't have to say, yeah, it's true. If you reduce it from 30 to 10, who knows if that makes any difference at all? Doesn't matter. The government says it does. We say, okay, it's a compelling interest. What's your end goal? Reduce guns, reduce deaths by guns. Okay. That's compelling. That's a compelling interest. Now, are you doing it in a way that is the least restrictive way possible? Here, court says no. You're banning everything everywhere. It's a statewide ban. There's no exceptions. There's no little pressure relief valve. What if somebody has a very good reason why they need a higher capacity magazine? You're not providing an escape hatch for them to go and achieve that. And since we know that the Second Amendment is a fundamental right, and they're applying strict scrutiny, we need that escape hatch. Otherwise, this cannot be deemed to be the least restrictive means. The panel held that even if intermediate scrutiny were to apply, the penal code would still fail. It held that interest expressed by the state qualified as important. The means chosen to advance those interests were not substantially related to their service. So even if they drop that standard from strict scrutiny down to intermediate scrutiny, where the government has more leniency, sort of the higher the standard, the more the government has to prove it's necessary and there's nothing else they can do except this. Intermediate would have dropped that down a little bit. So it wouldn't have to be compelling. It would have to just be important. It wouldn't have to be necessary to achieve the government's goals. It just needs to be, substantially related to achieving those goals. Whereas at the very low standard for rational basis, it is, it's rationally connected to an outcome so the government can do whatever the hell they want. And here they're holding it to that high standard. So the question then becomes, what is the court going to, what standard is the court going to use? Why are they hearing the whole case? What part of the analysis are they going to disagree with? Are they going to say that, no, it shouldn't be a strict scrutiny analysis? They're going to drop it down to intermediate or rational basis? I'm not sure that that's going to be that compelling. Are they going to argue that it's not a fundamental right and therefore it should just be rational basis scrutiny because it's a magazine and not a firearm? In other words, you're allowed to have the firearm. They're not infringing on your right to possess a firearm. They're just saying you can't have a magazine. Do you think that's compelling? Well, here's what the judge that dissented said. She would reverse the district court's grant of summary judgment. So she would have not, Judge Lynn, I think it's a she, Judge Lynn wrote the majority opinion conflicted with this circuit's precedent, FIOC, and with decisions in all 6 sister circuits. that address the Second Amendment issue presented here. Judge Lynn would hold that intermediate scrutiny applies and that it satisfies that standard. So we know that one judge is saying, no, it's not strict scrutiny. Down here, intermediate scrutiny, which means the government has to show a lot less. Doesn't have to be necessary. Doesn't have to be the least restrictive means. It's just important. And it's close enough related to that important interest. So what do you think about that? Let me show you just briefly. We'll run through some of the innards of this opinion. Second Amendment is a fundamental right rooted in both text and tradition. So this is the majority opinion that's in writing here. In McDonald versus City of Chicago, a citizen's right to self-defense held is deeply rooted in the nation's history and tradition, fundamental to our scheme of ordered liberty. Many legal systems from the ancient times to the present day have recognized the right to defend oneself from the aggressors. They also reference the Constitution. Second Amendment. 2008, the Supreme Court in Heller said the Second Amendment protects an individual right to keep and bear arms. The court then incorporated that into the states through the 14th Amendment a couple years later in 2010 in McDonald versus the City of Chicago. So on a federal level, you have a Second Amendment right for an individual to keep and bear arms under Heller federally, incorporated to the states in 2010 under McDonald. Under this court's precedent, the penal code, in the majority opinion, they say it runs afoul of the Second Amendment. Proper standard of constitutional review cannot withstand this level of scrutiny. The Ninth Circuit employs a two-pronged test. We already talked about that. Whether the law burdens the conduct that is protected by the Second Amendment, and it certainly does. And if so, what is the appropriate level of scrutiny? We already talked about that. It is strict scrutiny, prong one. California Penal Code, it burdens protected conduct. How do we know that? Well, number one, firearm magazines are protected arms under the Second Amendment. They do a lot of analysis on that under paragraph 1. LCMs are not unusual arms. They're not. They're just magazines. They've been around for a long time. 30-round magazines and things more than 10 rounds have been around forever. LCM prohibitions are not long-standing regulations. It's a new phenomenon. Therefore, they do not enjoy a presumption of lawfulness. They're new. They're just now trying to regulate these things. There is no persuasive historical evidence in the record showing that LCM possession falls outside the ambit of Second Amendment protection. So this is prong one. Prong two, strict scrutiny. How do we know that that applies? It strikes at the core right of law-abiding citizens to defend themselves by banning LCM possession. It's a fundamental right because the Supreme Court said so. We saw that in Heller and McDonald. California Penal Code also substantially burdens the Second Amendment right. They're saying self-defense is a fundamental right rooted in national history. California Code substantially burdens that. Decisions in other circuits are distinguishable. FIOC does not obligate us to apply intermediate scrutiny in opposition to the dissent. It does not survive strict scrutiny review because the state interests here, they are compelling, but it's not narrowly tailored to achieve that compelling interest. Even if intermediate scrutiny were to apply, and the reason why I wanted to just point this out is let's go forward and let's say that, all right, we get back to a full panel of 11 judges. What are they going to apply? What different level of scrutiny? If they say intermediate scrutiny, well, how do you deal with that? If you're a Second Amendment person, well, the majority in this opinion has already responded to that. They say intermediate scrutiny, as traditionally understood, has a bite, which means it's a little bit higher, right? It's not closer to rational basis. It's closer to strict scrutiny. Appellate courts have not settled on a particular intermediate scrutiny formulation for Second Amendment challenges, which is why intermediate scrutiny is sort of just kind of this, it's intermediate. It's, stuff will typically fall into one of the other two categories, and they try to squeeze this one in here when they try to make stuff work, is my read on it. 3, some courts have applied a diluted form of intermediate scrutiny that approximates rational basis. So they're trying to, when they don't like rational basis or strict scrutiny, they try to cram it in intermediate scrutiny. And then the California Code would still fail to pass constitutional muster, even if it was intermediate scrutiny. In conclusion, Let us be clear. We are keenly aware, and this is a little bit troubling if you're a Second Amendment person, because they're sort of passing this and then they're walking it back a little bit. We are keenly aware of the perils of gun violence. The heartbreak, devastation caused by criminals wielding guns cannot be overstated. We also understand the importance of allowing state governments the ability to fashion solutions to curb gun violence. We have thus held that California can, for example, impose waiting periods, require micro-stamping of guns, and forbids felons, the mentally ill, or misdemeaning ants convicted of domestic violence from owning firearms. We also want to make clear that our decision today does not address issues not before us. Very limited decision. We do not opine on bans on so-called assault weapons, nor do we speculate about the legitimacy of bans on magazines holding far larger quantities of ammunition. Instead, we only address California's ban on LCMs as it appears before us. So they're saying here, do not read into this. On this case, under this law, in this situation, we're going to invalidate that ban. But if something else comes down the line that we don't like, we're going to reserve the right to distinguish this case from anything that's forthcoming. And we may change gears later down the road. We may support an assault weapons ban. We may support another ban on increased magazines. We don't know yet because it hasn't come up, but now this is going back to the full court, so we may learn more. We understand the purpose in passing this law, but even the laudable goal of reducing gun violence must comply with the Constitution. California's near categorical ban of LCM infringes on the fundamental right to self-defense. It criminalizes the possession of half of all magazines in America today. It makes unlawful magazines that are commonly used in handguns by law-abiding citizens for self-defense, and it substantially burdens the core right of self-defense guaranteed to the people under the Second Amendment. It cannot stand. We affirm the district court's grant of summary judgment in favor of the plaintiffs. And so that is what removed the ban, or basically put a hold on the ban. Said the ban is not constitutional, but now this has all been vacated. It's all going to be reheard at the Ninth Circuit, and we'll see what they do with it. Chris Wiseman in the house with a question over from locals.com says, as I understand, the Ninth Circuit is the exception to en banc hearings. The Ninth holds a lottery for the panel judges plus the Chief Justice of the Ninth. All other circuits have the full included in the en banc hearings. Yeah, you might be right, Chris. I don't know. That's a good question. I really don't know the answer to that question. It's technical, but I think that sounds like you got a good grasp on it. So take that for Chris Wiseman's word. Ninth Circuit holds a lottery for judges, so it's not going to go to the full 11. It'll be the 9 plus the Chief Justice. Thank you for that, Chris. We have another one from CA Java Bean says, shouldn't there be an exceptionally high standard of review when the potential tyrants are trying to impair the civil right aimed at taking out tyrants? Yeah. Well, strict scrutiny is pretty high. And, I think the Supreme Court has been pretty clear on this in 2008 and 2010. So, I think they're going to make a lot of nibbles around the margins here. So in this case, let's just sort of hypothesize here. What if they go and pass a new Prop 63 and they carve out some exclusions? And they come back and they say, well, yeah, we know that it was a categorical ban on LCMs, but now we're going to modify that. So we're going to say, well, it's not as categorical. It's categorical unless you apply for an exception to that and you show good cause for why you should have higher capacity magazines. Well, now it's not categorical anymore. Maybe it survives strict scrutiny under this court's interpretation of the rules. Hey, Rob from Osaka says, I keep noticing laws that the people pass keep being changed by a small group. Example, Arizona weed law, Arizona court judges minor tweaks to the laws. I'm shocked that's even possible. With the only option is to vote them out. Irony. Seems like this just opens the door for corruption. Yeah, well, that's just politics, I think there, Osaka. I mean, this is what happens everywhere in this country. Something starts out, isn't there like a funny cartoon on YouTube somewhere where a bill starts as a bill and then a bunch of people stuff it with pork, and it by the end of the day, after it goes through all the committees and it lands on the floor and it gets voted into law, it's not even remotely anything resembling the bill. And we've seen this actually happen in real time. This happens all the time. We're passing a COVID-19 relief bill. Why the hell is there money in there to save the owls in Minnesota? What are you talking about? That's just an example. I don't know if it's really in there. Probably, because everything's in there. But yes, there's a lot of pork. There's a lot of corruption, a lot of malfeasance that happens in the drafting and running of this country. We have Ma Fox says, as for your example of magazines not being part of firearms, therefore not subject to rights granted via the Constitution, you have a right to health care, but you have to pay for it. It's not much of a right then, is it? Yeah, that's a good distinction there. I like that analogy, the healthcare analogy. Yeah, I mean, I think it's kind of the same argument with some of the free speech stuff, right? People say a lot of that, well, you have a right to free speech, but you don't have a right to say certain things, or you don't have a right to a particular forum. You know, it's sort of like, well, you have a right to equal rights if you are talking about race. You have a right to, back in the 1960s, right? You have a right to ride a bus, but you can't sit in the front. You have a right to a restaurant. You have a right to eat food, but not here. You have a right to come sit down in this park, but not on that bench. You have a right to drink water, but not that fountain, right? And we've all recognized that that's just ridiculous across the board. That's stupid. There are certain fundamental rights that we think exist, and those should, in my opinion, we should be able to express those as fully as possible, as long as it's not impeding on or interfering with another person's rights. Good question. Good comment there, Ma. The Second Amendment seems pretty clear. I feel that any prohibition on gun ownership on individuals that have served their sentences is an infringement. That comes from liberty or death. Yeah, you know, Liberty, I think that even Amy Coney Barrett agrees with that. So you're in good company. You got a Supreme Court judge. I think that's what she has said. There was a case that we reviewed that she, I think, was on the majority of saying that, or in the minority, I think, in the dissenting opinion on some case. I might have to double check on that one, but I think she said specifically that there's no sort of common law basis for keeping felons from possessing firearms. In other words, the prohibition on firearms for felons is subordinate to their right to possess a firearm, because when the Second Amendment was being contemplated back during the founding era, there was no real discussion about being convicted of a felon would impede your ability to have a firearm under the Second Amendment. Interesting debate surrounding all of that. All right, so our last segment for the day before we get on out of here on this Friday, we've talked a lot about Jason Ravnsborg, the Attorney General out of South Dakota. Some time ago, I believe it was back in September last year, he was involved in a very serious accident. He hit somebody on his way home from an event. The Attorney General for South Dakota, the chief law enforcement officer of the state, driving home, hits and then kills somebody. And something interesting happened. He went home, and the next day came back to the scene, realized it was a person. The night before thought it was a deer, came back, oh, it's a person. Then the police get involved. Now, as a defense attorney, when I hear something like that, anytime I hear about an accident, whether it's Tiger Woods or anybody, first thing that crosses my mind is, are we talking about a DUI situation here, right? And that's the first thing the police think as well. Now, for a normal person who's not the Attorney General, who is not the chief law enforcement officer of a state, if you called the police a day after you hit somebody, they would be asking a lot of questions about that. Well, why didn't you call before? What do you mean you thought it was a deer? Because it's a little bit different, a person and a deer, and they sort of ask a lot of questions. One of the other things that they would be asking is, why didn't you call us that night so that we could have taken a blood sample from you on that particular night? If you wake up the next day, any of those intoxicants that are active metabolites, most of them are going to be out of your system, especially if it was just a little bit of something. So he did take a blood test, but it was the next day, not that night. Now, people who were there at the event say he wasn't drinking, he wasn't doing anything. But my little defense attorney spidey senses have been tingling on this one for a long period of time, which is why we've been covering it. Now, today, there's new information that came out. We covered this earlier in the week, or it may have been last week, where he was not charged with any felony crimes for killing a person with his vehicle. He was charged with 3 different misdemeanors. One was for, I think, using an electronic device on his way home. The maximum amount of time he could get would be a couple months in jail. Whereas anybody else, I think, in this situation is much more inclined to be charged with vehicular manslaughter or negligent homicide or any one of these other more serious charges that, of course, because he is the chief law enforcement officer of the state, he gets away with a little bit less than that. And today, now that the new charges have been filed, well, a lot more information starts leaking out. This story came over from rawstory.com. Says embattled South Dakota DA was reading Joe Biden conspiracy theories on his phone when he killed a pedestrian with his car. The embattled Attorney General, Jason Ravnsborg, admits reading Joe Biden conspiracy theories on his phone moments before fatally striking a pedestrian with his car. And so, you know, if you've been following this channel for some time, you know that I'm a free speech person. I'm a free speech advocate. I love free speech. I think it's critical to us having good conversations. And I've been very critical about a lot of the Democrats and a lot of the media out there saying, whoa, this is dangerous. You're a conspiracy theorist. Well, now we know that conspiracy theories are dangerous, because if you're reading one while you're driving home, you can hit and kill somebody. So I guess I was wrong on that one. Conspiracy theories are dangerous. Not for the same reason, but for another reason, because it can result in you killing somebody with your car. Detectives examined Ravnsborg phone records. They found that he logged into his Yahoo email account at 10:20 on September 12th. Moments later, he was viewing an article on the Dakota Free Press website. A minute later, he went over to Real Clear Politics. Minute after that, and moments before he struck and killed 55-year-old Joe Bover, he was viewing an article about Biden on disgraced reporters John Solomon's Just the News website. Is John Solomon a disgraced reporter? I don't know who that is. Ravnsborg doesn't deny reading the article, which Media Matters researcher Thomas Johnson pinpoints as a September 11 piece on an alleged self-dealing by Democratic presidential candidate and his son, Hunter Biden. Well, I remember looking at it, Ravnsborg tells investigators, but that's when I set my phone down prior to the accident. He agrees that he waited a minute or two before calling 911 to report the accident, which he claimed at the time involved a deer and not another man, and phone records show an outgoing call from his phone at 10:24 p.m., which is almost the same time he was reading Biden conspiracies behind the wheel. South Dakota Governor Kristi Noem, a fellow Republican, has called on him to step down, and the GOP state rep Will Mortensen has filed articles of impeachment against the Attorney General. He's facing 3 misdemeanor charges in the death. Timothy Johnson posted on Twitter, Ravnsborg was reading Joe Biden conspiracy theories at John Solomon's Just the News website while driving. He hit and slammed and killed a man, hitting him so hard the man's face came through the windshield. Ravnsborg claimed he thought he hit a deer. And how do we know that the man's face went through the windshield? The face of the man through the windshield when he was driving. He thought it was a deer. Let's listen in.
Here's kind of the information that was put together on your phone and here's our times. So, outgoing call, 10:24. So that's what time you made the 911 call. So, and that's all fine and dandy, you know. But leading up to that, at 10:20, you unlock your phone, signed into your Yahoo Mail account. Also, then signed out. At 10:20:49, you were on the Dakota Free Press site. These are all on your work phone. A minute later, you were on the Real Clear Politics website. And then about a minute later, this article was pulled up through the Just the News, which could have been something that you were on this and it had a link to click to get you to this one regarding this. It's an article about Joe Biden and something with China. So you were on that up to about, we're going to estimate probably a minute before the accident. You were on that. Do you remember any of these?
Well, I remember looking at it, but that's when I set my phone down prior to. Yeah.
Okay. Because then, like I said, we're looking at a minute to 2 minutes before you call 911.
Right.
So, the concern being is that we know that from the time of impact, there was a time period that went by before you called 911. You had to realize what was going on, come to a stop, get your bearings back about you, get out, look at the damage a little bit, figure out what the hell is going on. You're trying to figure out where you are, call 911. So it's reasonable to say that there was a minute to 2 minutes that passed from impact to when you were actually on the phone with 911, right? That would be reasonable, correct? I mean,
I guess, yeah.
Okay, so repiecing together the timeline doesn't kind of make that much sense, right? He's saying, well, I set it down, and he says, well, kind of, but not, because there was a period of time when you had to call 911, and so maybe that was the time where you were getting your bearings straight. That wasn't you setting the phone down. That was you getting out of the car and looking what the heck happened before you called the police. So first of all, that alone, I think, would lead to more serious culpability for a lot of people, right? If you're not the attorney general of a state and you're on your phone texting and reading articles while you're flying down the freeway and you hit and kill somebody, do you just get charged with misdemeanors on that if you are a non-attorney general? Not in my experience, okay? This is a little bit of, we can call it attorney general privilege if you want to use the woke vernacular. Here is another clip from the interview. Asked by investigators why he returned to the scene the next day to look for the deer. Yeah, well, why would you return to look for a deer? Suspicious, Timothy says. Ravnsborg pats himself on the back for finding the body. To my credit, if I didn't find him, how long would he have laid there?
The next day to look to see what your
Now,
deer looked like.
I got that, and I didn't go back to look at him because I thought that I'd hit a man. I went back because the debris was still there.
No, what I'm saying is, I asked them how many of you went back to look at the deer,
Right,
to find the deer,
right.
and none of them did.
Well, yeah, but most of them probably found the deer or
Right.
left the scene from there. I mean, I'm bringing it back, and if I wouldn't, I thought I was doing the right thing, getting gas to give back to the sheriff. And I said, well, let's look for, the deer. I was just curious of how did it play out. It just felt like a thunderbolt hit my car, And where did he go? Maybe he went to the other side. I didn't know. And I was kind of trying to put my mind at ease of how did this happen? But I guess to my credit, I'm also like, well, if I didn't find him, how long would he have laid there? And I told the sheriff, and the sheriff was surprised. The sheriff's on the scene at least twice, and so is the tow truck driver. And none of them thought it was suspicious that it was not a deer. I guess I wasn't there when the tow truck driver was there, though, so I don't know what he saw or didn't see, but he didn't jump up and down and tell the sheriff, hey.
Yeah, there was a whole lot. I mean,
Right.
the car was gone.
Right.
Obviously, you were gone. Tow truck guy is gone.
Right.
But we tracked everybody. I mean,
Right.
we're tracking
I would think so,
everybody
yes,
down.
absolutely.
We're not leaving anything uncovered.
Well, I get it, though. I get strict scrutiny because of who I am,
Yep. Well, I think this would happen no matter what. Because I think your guys would be sitting in these chairs if it was somebody else. And I think you know that.
I did not see him the night before. I did not find him until the next day.
They don't buy that even a little bit. You see their body language. They're having a conversation with the guy. Now, I mean, to his credit, he's talking to them. The first thing that anybody in that position would be advised to do if they were one of our clients would be, you do not speak. You stop talking, right? He's talking. Now, he's an experienced lawyer. He's somebody who is the attorney general. He's got this little power dynamic. So I'm not sure who the guy in the green is. The other guy looks like just sort of an investigator who kind of does this thing, and he is asking the traditional questions. The guy in the green may have been somebody from an outside entity, somebody who, without a conflict of interest, who is being brought in to do this questioning. And I think as more details come out, we'll figure out who these people were. But they're looking at him like, bro, are you serious right now? I just showed you the timeline, and you think that all matches? Over on Law and Crime, here's what they say. The initial accident report said the Attorney General was not intoxicated, but confirmed that he was distracted. He was traveling on U.S. Highway 14 entered the north shoulder while traveling westbound. Bover, who he hit, was walking on the north shoulder. Bover was struck by Ravnsborg. He was carrying a light. Bover was carrying a light while he was walking down the road. The exact time of the crash is still under investigation. The specific distraction is still under investigation. A blood sample wasn't taken until 15 hours after the fatal crash. Sample turned up no alcohol in the toxicology report. But 15 hours, if you had a couple drinks, the general rule of thumb is sort of one serving every hour. And this depends on your body weight and how much you drink and what you drink and all of that stuff. But one serving will dissipate out of your body as a general rule of thumb an hour. So if you have 3 beers with dinner, probably should be waiting about 3 hours before every one of those servings dissipates out of you. Ravnsborg, after his car was wrecked, drove home that night in a vehicle owned by the Hyde County Sheriff. His body was found the next day. Ravnsborg returned to the scene in the vehicle he borrowed. He claimed that this was when he realized for the first time that he killed a man. At one point during the interview, investigators confronted Ravnsborg with the truth that Bover's reading glasses were recovered from inside the Attorney General's vehicle. One more time. The investigators told Ravnsborg with the truth, they hit him with this. The man you hit, his reading glasses were in your car. Inside the car. His face hit your windshield, Jason. Think about that, an interrogator said. Ravnsborg denied knowing anything about the glasses found in his Ford Taurus. He faces 1 count of careless driving, operating a motor vehicle, and a lane-changing violation. Each of those are Class 2 misdemeanors. Those charges came down on February 18th. Since then, momentum has grown amongst those in South Dakota in favor of his impeachment. The interview analysis, the victim's glasses found in the car, cell phone use among key moments. Bover was carrying a phone flashlight when he was struck. In the video, one interviewer said that the flashlight was still on the following day when investigators arrived at the scene. So have you ever seen a deer with a flashlight? Ravnsborg denied seeing the flashlight. He previously told investigators he got out of the car after the crash to inspect the damage. He denied seeing the flashlight at that point as well, even though the flashlight was on the following day when investigators arrived at the scene. So the next day they come in the daylight and they can see it. He's out at night after he hit the guy. After the glasses and the face came through the windshield and landed in his car, he gets out, flashlight's on, can't find the body. Calls 911. Oh, I thought I hit a deer. Goes home, comes back the next day. Blood results 15 hours later. Oh, I guess it was a guy. Cops show up and say, yeah, we know. There's glasses in your car and the flashlight's still on. The interviewers noted other witnesses had reported seeing Bover carry the flashlight. They also said investigators later returned to the scene at nighttime and placed the flashlight in the spot it was found to see how well it could be seen. It's hard to miss, one interviewer said. Another interviewer said it was like a beacon and easily visible from either side of the road. Another article from Fox News. State Department Public Safety today released recordings. 55-year-old Joseph Bover's dead. Shows September 14th interviewers. They asked him about the glasses again, telling Ravnsborg that they had belonged to the victims. They're Joe's glasses, an agent says. So that means his face came through your windshield. Upon hearing that, Ravnsborg looked down and sighed deeply before shaking his head, the footage shows. I did not see those glasses until you showed them to me. The agent told Ravnsborg that the only way for them to get there is through the windshield. His face was in your windshield, Jason. Think about that.
Did you see the glasses right?
Oh, sorry.
Did you see the glasses right next to that?
I did not.
Okay.
You showed me the glasses the first time. That's the first time.
They're Joe's glasses.
I wondered about that.
So that means his face came through your windshield. It's a tough thing.
Oh, I was thinking that his face did not come through because it would have been blood. I thought there'd been blood everywhere. Then now, I've thought about it.
Yeah, I mean.
No felony charges for this guy. We'll see. That can change. We'll see. we'll see where this goes. Let's jump into some questions. Hack Consulting, these questions are over on Locals. What's up, Hack? Says, we do not know what the unofficial correspondence was between the defendant and the police. There are patterns that the defendant, as a prosecutor, has interests that align with the police in order to activate a form of blue shield protection. As such, if I were prosecuting, is there a way I could use this lack of evidence to hammer the defendant? So yeah, I mean, you would absolutely want to look into this stuff. You would want to subpoena all of those records, any emails, any text messages, any cell phone stuff. I would guess that he was pretty by the book on that, since he knew that would happen. I mean, you saw sort of the depth that the interrogator went through on the timeline. Every single website, how long he was on there, all of that stuff is retrievable off a phone. We have a company that we use that helps us do that. A former defense attorney who has just sort of turned in to an expert witness on a lot of the digital stuff. And he says they can basically get whatever they want off your phone. I mean, it's the amount of data that's there is insane. So when people are worried about tracking devices, he's like, well, you already got one. It tells everything, records everything you do, up, down, left, right, front, back, doesn't matter. It's all on there. And I would imagine that attorney general would have known that as well. So if there were communications that were happening, those would have had to come from a burner phone or from something that is, sort of outside of the scope of the investigation. But I think that he knew how to play it, and he had a good poker face, and he created enough distance between that night and the next day that it's hard to pin him down. Now, did he get a benefit of the doubt by calling 911 and saying, oh, it's the attorney general here. I'm Jason Ravnsborg. Listen, I hit a deer. I'm going to go home. I'll be back tomorrow. We'll take a look at it. Just want to let you know. Okay, sounds good. Thanks, Jason. We trust you. We know you're good. You're the attorney general. All right, we're not going to question you. He gets a lot of benefits that other people wouldn't get. We have another one from Dr. Renal MD. Says, I know he's a lawyer. First question, where is his lawyer in those police talks? Yeah, I know. That was, watching these just made me just go, oh, just, cringe. And if he, if this continues to develop and there's enough sort of public outcry about this, they may reconsider some of this as new evidence and maybe go in front of a grand jury and have the grand jury decide whether to indict him or not. I don't think that happened in that first decision of those charges. I think that was just a decision from the city prosecutor or from the county prosecutor or whomever made that decision. But there may be enough sort of momentum here that they decide to take this in front of a grand jury and see if they want to indict. Pinky 2 says, I can see why he's in the hot seat, but question, would they have looked for skid marks the night before, or because he was a deer, they don't look at skid marks? Where was the man walking on the road? Yeah, they should do all of that. I mean, they'll do a very in-depth accident reconstruction. I mean, at least in Arizona, my experience is they have dedicated units that will go and reconstruct accident scenes. Now, sometimes they do a great job, sometimes they don't. And in this case, it wasn't done immediately. It was probably done, 10 hours later, 12 hours later. So, some things could have changed. Other cars were going by. Presumably, they would still be able to identify if there were skid marks or reconstruct how that happened. And they can actually do some pretty amazing things with a lot of the technology now. Basically, recreate everything in 3D and apply real-world physics to it, put the make and model of the car in there, adjust speeds, and just recreate the whole thing. Personal injury lawyers do a very good job at that, but regardless, back to the doctor's point, he should not have been speaking there. I think what he was trying to do was, talk his way out of it and use a lot of his. He's thinking about multiple things. He's thinking about not being charged with a crime, but also probably his future political career. And they're sort of at odds with one another. If he would have lawyered up, then it may have been better for his criminal case posture. In my opinion, absolutely it would have been. But it would have been very adversarial to his future political ambitions, right? The people in South Dakota, presumably, would be saying, what do you mean you're not answering questions? Okay, you're an elected government official. You were in a government vehicle. You took a government vehicle, picked you up in a sheriff's vehicle, took that home. You sort of were using governmental resources to help you work your way through this. And you are the chief law enforcement officer. So if you're all about, punishing crime and moving the needle in your elected capacity, well, we expect transparency from you. And so if he would have lawyered up, I think he would have absolutely crushed his future political ambitions, which may be foregone anyways, based on his answers to those questions. Ma says, it was just Bambi carrying a flashlight and his large bifocals. Anyone not him would be in prison for murder due to negligence. Yeah, negligent homicide. Yeah. It would have been an easy charge. Vehicular manslaughter. Looking on your phone. It's just Bambi. Did Bambi have a flashlight? Here's Jeremy Madrid. I just said, has anybody seen a deer with a flashlight? Boom, Jeremy comes in, clutch, and there it is. Yeah, we have a deer with a flashlight. So Ravnsborg just thought he hit one of those deers. That's all. Now it makes sense. Now I believe him, actually. Innocent. All right. We have Wise One. Last question of the day before we wrap it up. A Wise One says, what is the blue shield? And my real question is there any kind of connection between these two men? So I'm not sure which two men you're talking about there, Wise One, whether it's Ravnsborg and the person he hit, Bover, or whether it's between Ravnsborg and the two interrogators. So I don't know. I don't know the answer to that. Probably not between Bover. I think that probably would have come out at this point in time if they had known each other. I think Bover, a vehicle broke down and he was walking, or he was just trying to go get help. So just walking on the side of the road, had his flashlight on. Ravnsborg is reading dangerous conspiracy theories and hits him. Face goes through the windshield, enough so that the glasses are inside the vehicle. Thought it was a deer. A flashlight deer. Yeah. Okay. The blue shield, though, Wise One, it's this concept that the police protect their own. That anytime there is a law enforcement official who's in trouble, all of the other officers circle their wagons around that individual. The shield goes up and they protect themselves. They investigate themselves. They find, we didn't do anything wrong. It was all policy. It was all by the book. No problem there. And they just bend the rules a little bit. Oh, okay, so if it was a normal person who's not the attorney general and you hit somebody, you call 911, they say, don't you move. We're sending a unit out there. We'll be there in 10 minutes. All right. Yes, sir. Okay, I'll stay right here. Shows up, get a contemporaneous blood draw, take a look at it, get his initial statement before he's had time to think about what happened. You start gathering the evidence in real time. But he's Jason Ravnsborg, the highest, most powerful elected law enforcement official in the state. He gets special treatment. He gets a ride. He gets to go home, and the investigation takes place the following day. Everything's a little bit wobbly now. The interrogators are a little bit off. So maybe they just let that go a little bit longer than they would have for somebody else. You get some special privileges. That's the blue shield. It's protecting them, whereas you or I in that same situation wouldn't be afforded any of those same privileges. So that's it for the show today, my friends. We're wrapping up a little bit early. I want to thank those of you who asked questions. Those, of course, came over from locals.com. All of you who are supporting the show over there, we very much appreciate you. We have Takahara. We got Farmer's Daughter. We got Chris Wiseman was in the house today. We have Ham-Handed. We got Liberty or Death with some questions. Just XUXA sent me some nice pillows. Hack Consulting was in the house today. We also have Wise One asked some questions. We have Shades was in the house. We've got Cats59, Cax Axe, Ryan with a 0, CRS Lanina. We got Dilius. Then we've got Fair Dinkum. We've got Ross Cares 22. We got KT Sherlock. We got Joe Snow in the house, no doubt. SF Bob. And we had one new person sign up last night. Welcome to American_Warhawk. Is joining us over on Locals, where we are continuing the conversation both before the show, after the show, during the show, especially during the live chat, and we're sharing links. We are posting PowerPoint slides, as well as some other pretty neat little things. We've got my book is available over there. It's called Beginning to Winning, How to Fight Your Case and Succeed in the Justice System. PowerPoint slides will be there. Impeachment party proceeding will be there. We've got the existence systems, which you can take a look at, as well as links and great people who will be over there. And a little announcement. I think that we're doing a live stream tomorrow at 2 p.m. Arizona time with Mr. Robert Barnes. Many of you who are sort of bouncing around the legal YouTube space, I think we've got that scheduled. So Miss Faith was working on that. So I think we're going to be talking a little bit more about some stuff that's going on in his wheelhouse, as well as the Digital Bill of Rights. I want to get his thoughts on sort of the current environment from a lot of things. I think he's a very articulate man, brilliant attorney, and I want to get his thoughts on a lot of this stuff, especially since we sort of operate in the same wheelhouse. So I hope you join us for that. Keep an eye out for when that will be. I do need to confirm that, but it's looking like it's 2 p.m. Arizona time tomorrow, 1 p.m. on the West Coast. That would be 4 p.m. on the East Coast. So I want to invite you to join us for that. So keep your eye out for it. Lastly, but not leastly, I am a criminal defense attorney. So if you know anybody in the state of Arizona who has been charged with a crime, we would be very honored if you sent them our way. We're good at what we do. We help people with all types of criminal cases. We offer free case evaluations. And so if you know anybody in need of some support, whether they have an active open case, an old closed case, we can help. We like to provide safety, clarity, and hope to good people charged with crimes in their cases and in their lives. So if you know anybody, we'd be honored and humbled if you trusted us enough to send them our direction. Other than that, my friends, I want to thank you so much for tuning in. Everybody have a lovely rest of your Friday evening. Have a very restful sleep, a nice, comfortable weekend. I'll see you back here on Monday, if not tomorrow, back here tomorrow at 2 p.m. actually. Then on Monday will be the same place, same time, 5 p.m. Arizona, 4 p.m. in California, 6 p.m. Central, 7 p.m. out there on the East Coast. Everybody, thanks once again. Have a wonderful weekend, lovely evening, and bye-bye.